is on trust as well, and that's not primarily a legal but a political question, and that's more your responsibility than the responsibility of a data protection authority. But let me, as a data protection authority that has been in politics for nearly 25 years in Dutch politics, say this. Based on the reports in The Guardian, New York Times, Washington Post, Der Spiegel, and since this week also Brazilian Globo, it is highly likely that the fundamental rights of Europeans have indeed been infringed upon. Our right to live a private life, our right to secrecy of correspondence, our right to data protection, all these rights that form the fundamentals of trust in the relation between government and its citizens are at stake. So what's next? The Working Party shall continue to ask for the facts and will, to the best of our ability, make the analysis that is needed to draw legal conclusions. So what do we need to know? First of all, it needs to become clear what information is actually collected through the NSA surveillance programs. It is clear that information is collected at a very large scale with limited safeguards in place, and the safeguards that do exist apparently are only intended to protect Americans. One point that has been revealed is that data may only be accessed if they originate from non-US persons and are collected from sources within the US. We, however, need to know when US authorities consider personal data to be inside the US. Due to the continuously increasing use of the Internet for processing personal data, where much information currently is stored in the cloud, we do not know the exact location of data sets anymore. The same effect is caused by the global scale of backbone networks and their inherent capability to convey a wide range of communication services. It thus needs to become clear whether the intelligence services or other relevant bodies have to prove that the data are physically and legally available on US soil, stored on servers on US territory, or if it is sufficient that data are processed by or through an American company, a subsidiary. So clarification is also needed about the involvement of the FISA court, both in terms of procedures and the moment it is seized, as well as the conditions and criteria the court applies in its decision to allow surveillance orders of non-US persons under US legislation. We need to be able to assess to what extent these orders are narrowly targeted enough and substantiated sufficiently to allow for a limitation of individuals' fundamental rights on national security grounds. We believe that, as is the case in Europe, necessity and proportionality should be part of the considerations before deciding to infringe on fundamental rights. News reports suggest that the FISA court has developed what is believed to be a secret body of law on surveillance and has set rules for the collection, use and access of data on the basis of various intelligence programs. While it is always good if criteria limiting the processing data are in place, it is very problematic if these criteria are kept secret. Now let me add that as far as we know, also European intelligence agencies and their supervisors struggle with providing information to the general public. In a democratic society, it's however important that a public debate can be held to verify under what conditions intelligence operations take place and what methods of supervision are in place. I think President Obama rightly said it's not enough anymore in this time that the President trusts its intelligence services. There's more to be done about it. There are many different ways of intelligence supervision in the European Union as such, and the key question is what should we consider best practice? And strange as the FISA court construction may be, do we think that Europeans have put the intelligence community under a higher level of scrutiny? I don't know. Another issue at stake is the relation between the surveillance programmes on the one hand and compliance by organisations with the conditions for the third country transfer of personal data, including standard contractual clauses, BCRs and the safe harbour principles on the other hand. The safe harbour principles indeed to allow for a limitation of adherence to the principle, and I quote, to the extent necessary to meet national security requirements, end of quotation. However, with the Working Party, there are doubts whether the seemingly large-scale and structural surveillance of personal data that is now emerged can still be considered an exception strictly limited to the extent necessary. Safe harbour is likely to become crucial in the debate on the possible implication of PRISM and PRISM-like programmes. But we need to proceed cautiously here. The Working Party is currently discussing to what extent, legally spoken, this is a matter of international transfers. Much depends on where the data collection takes place, which is one of the facts that hopefully will be established by the expert group. If you ask me now, I would therefore, in all honesty, not be able to tell you what the consequences of the surveillance programme for the Safe Harbour Agreement can be or should be at this time. The Working Party is, of course, very much aware that it is not only the United States who make use of such surveillance programmes. Several European member states are also revealed to monitor communication on a structural basis, either using upstream or by tapping the internet. Programmes like, for example, Tempora, will also need to be assessed in the light of European fundamental rights legislation. We will endeavour to do so together with our colleagues on the national level, taking due account of the limitation that our national legislations have put in place. Not all DPAs are competent to supervise intelligence agencies, including my own Dutch DPA office. So once again, we found ourselves, I think, a little bit like the European Parliament, dependent on third parties to hand us the facts before we can carry out the required legal analysis, just as is the case for PRISM. Now, finally, it is clear the only solution to these discussions, at the end, trust being at stake, is a political one. In 2 weeks, data protection authorities from around the world will be discussing in Warsaw a proposal to add a protocol to Article 17 of the International Covenant of Civil and Political Rights. This proposal has also been done in the GHA Council and intends to reinforce the right to privacy on an international level. And maybe it is also time to start to discuss a global right to secrecy of communication, as some have suggested. Thank you, sir.
Thank you, Mr. Kohnstamm. Now we open the floor for discussion for the members. We get started with the rapporteur, Mr. Moraes. Please make it in 2 minutes so that we can widen the scope as much as possible.
I'll be very brief, Mr. Kohnstamm. Thank you for your work, and we hope to keep in touch with you throughout the inquiry. First of all, for the Working Party, you answered my first question, which is will you be assessing individual member state programmes like Tempora and so on, but you've really answered this question. So let me also ask you that in your letter to Commissioner Reding, you mentioned a number of items. Can I go more in depth on what you talked about on your independent assessment about the plans to assess the secrecy of the FISA court, and if the orders were substantiated enough to allow for limitations on national security grounds? Has your Working Party begun to investigate any of the declassified documents which have started to be disclosed in the press? You've seen that in the last few days. For example, this week we saw declassified documents as far back as 2009 starting to be revealed. And I won't go further than that because we don't have much time. But this is the kind of thing that we want to see you investigating and to go more in depth into. I would refer my colleagues to the letter you wrote to Commissioner Reding, which I think is rich in detail, which is why we want to keep in touch with you. And because we're short of time, Chairman, I'll leave my comments there. But thank you for your presence here today.
Thank you very much, and thank you for being here and doing the work also on those issues which are very important. And obviously you and your colleagues are also investigating into concrete opportunities, so I'm very interested in the question of the Safe Harbour Agreement, because I think that seems to be really an essential part now when questioning under which conditions personal data is transferred to third states, and especially in this case of the Safe Harbour Agreement, on the basis of the Safe Harbour Agreement to the US, where obviously the presumption of an adequate protection seems to be a bit too positive. So until now we debated on this agreement in a way that we said, okay, we somehow need to only better enforce, but obviously it's also a difference of legal surroundings which occurs, and that brings me to the situation that at the moment we cannot allow this agreement to stay, because it's obviously not in line with the circumstances under which the Commission could have or had agreed to it. So my question is also if there is such a procedure ongoing, and if you would advise us also to investigate in the opportunities which we also lined out in our resolution before summer, to ask the Commission to at least suspend this agreement unless these surroundings are clarified or improved. Thank you.
Herr Voss, sorry, you should have gone first.
Vielen Dank. Ich habe ähnliche.
Thank you. My questions are quite similar to those which have just been asked. Safe Harbour is something which is very important and which we have to address in detail. We know that in this agreement, the Safe Harbour Agreement, the Secret Services are excluded to a certain extent. So from the purely legal point of view, I'd like to know whether if a company then transmits that information to a third party, if the NSA were to be taking that information in, that could be viewed as Secret Service activity. However, within the Safe Harbour Agreement, it might be classified somewhat differently in terms of the company's activity. I'd like to know what the Article 29 group thinks about this. Do you feel that the allegations of violations of fundamental rights would be justified simply through that, or would these basic rights only be violated if the information which had been stored was subsequently analysed or processed in some way?
Thank you, Chair. A few quick questions. I won't address Safe Harbour because my colleagues have spoken about that. I would like to know, first of all, how Mr. Kohnstamm feels the facts that we now know, how that relates to the existing agreements on SWIFT and PNR. Secondly, I would like to know, the European Commission has often said that we need new data protection legislation in order to prevent this, and I've always maintained that this kind of practices are illegal even under the existing data protection legislation. Nevertheless, I would like to know about the data protection package which is currently being discussed by Parliament. If we amend I can't remember the number, paragraph 42 or 45, whatever it was, that was deleted by the Americans. If we amend that back into the text, will that be sufficient? And then finally, on the, let's say, the compliance or the voluntary, more or less, cooperation by companies, how does the Article 29 working group assess the fact that those companies have received payments in the order of a total of, I believe, $250 million, payments for their cooperation that go way beyond the coverage of costs? And secondly, could it be envisaged that European DPAs take legal steps against the companies that have complied and in doing so have violated European laws? Thank you.
Ms. Frau Ernst.
Thank you, Mr. Chair. Ja, folgende Fragen. Sie
I'd like to ask the following questions. You talked about the fact that secret legislation has been discovered regarding monitoring and surveillance, and the criteria are also secret. Clearly that has implications for anything we can do in terms of scrutiny, to put it nicely. So, in my view, this makes it impossible to scrutinise activities. What do you think? You said that a crucial factor is where the data is actually collected. Perhaps you could expand on that, what you mean by that. Tempora. Obviously, that's also another important element of this discussion. Seen from Germany, it's interesting to know to what extent links with other secret services are an important part of this whole inquiry. Safe harbour. So, to be blunt, is it really very relevant? So, as far as that's concerned, I would just like to echo the sentiments expressed by my colleague beforehand.
Vielen Dank. Ich versuche es ganz kurz.
I'll try to be brief. As far as I'm concerned, the Safe Harbour Agreement should be terminated. We've no idea what security measures are covered by this, whether or not they're complied with. Secondly, the data protection package is something which I think should be drafted in far more stringent or rigorous terms than has been the case up until now. And I think we should do far more to ensure the rules be complied with than many stakeholders have up until now. I'd like to know whether the reports you've seen up until now suggest to you that there are additional areas which also could be included in the agreement, which would offer or afford a further degree of protection. Another question. To what extent do you believe that the various different ways in which data is collected, those which we know about, those which we suspect, to what extent that data is processed or whether links are created between different pieces of information? The NSA has been accessing information. Do we have any idea as to what's been done with it, or has it been talked about? On SWIFT, I would also like to know what the whole point of this is. Will we ever have any evidence for the fact that the NSA has been collecting SWIFT data from Belgium? If that were to be the case, I think we really would be on very shaky ground. If the NSA had been doing that, we then have to ask ourselves what on earth the point of having an agreement was. This would simply be some kind of very thin cover for what the NSA had been doing. And if that were to be the case, we really would have to give fundamental consideration as to whether there's any point in having such agreements.
And thank you for being here. Just one easy question. You started by speaking about holes and backdoors in the program structure and in apps. Well, if we have holes and backdoors in programs, and those backdoors are used by US intelligence services, then most probably, those backholes can be used by hackers, by Chinese, by Russians. So actually what has been created is a mess where anybody can go into what we are doing, and nobody does anything about it. Thank you.
Okay, thank you, thank you. You also made it short. And Mrs. Moray.
Thank you. Two questions. The first is, what do we think the NSA actually does with all the data they collect? How do they abuse the data collected from European citizens? And the second is, what is the actual range of available legal remedies for the European Union or for member states or for individuals who were spied on? Is there a range of available legal remedies sort of researched or available? If you could share that with us as well. Thank you.
Thank you too. Mr. Kohnstamm, there you go for answers. We still have some minutes to go.
10 seconds per question. Let me first thank Mr. Moraes. I'll be willing to do whatever we can do to be available, at least, and help if possible, in the work the Parliament and you as rapporteur are doing. Maybe to take the last question is a sort of what powers do we in the end have? That's one of the main issues at stake. What do individuals, European individuals, have a right of redress? And it's continuously a discussion between the US and EU, where from US side is said there is not in practice very much difference between redress possibilities for US citizens and EU citizens, because also US citizens have scarcely any redress possibilities. We think if you look at the legal system that there is a big difference between redress possibilities for US citizens and for EU citizens. And as far as data protection is concerned, also in relation to intelligence services, we think internationally there should be an agreement that redress possibilities for both should be more or less the same. And the second question also of Ms. Mariah, available remedies. I think that in your questions you are touching on the political remedies that are there. PNR, Safe Harbor, SWIFT, all agreements that are in the end based on trust that they are used in the way they are being what the idea behind these treaties were. And if there is a leak by NSA or other secret services, then in the end we have done a lot of work without having come to the situation where we would have liked to come. Let me add to that, by the way, that the Working Party wasn't enthusiastic at all about these three agreements. So it's sort of criticizing in the end that maybe we should have done better from the EU side in getting these agreements on board. Now, as far as the discussion, without going into detail, is concerned between, as far as I've seen them, between EU and US on this case, there is a serious problem, and that is that if it's right that the national security services in the EU do more or less the same or use more or less the same information as the US intelligence services do, then we also need to get into, and I'm very happy to hear about that also the European Parliament is going to and trying to get into what the sort of balance between intelligence services on the one hand and data protection as being a fundamental right in the EU on the other hand in the EU is also taken care of. And there we're trying to find a way also within the working party, to get more in detail to what is the practice, so to say, on national level. We would be very much helped if more than until now is done, there would be declassified FISA material. Because some of the declassified FISA material, if I may be unpolitical, is 5 pages that are completely white and then 2 or 3 phrases that you can read. That's not the way we really would be helped to get grip on what the sort of surveillance is within the US. Yes. Let me then just stop, and I'm sorry. There's many. There's only one thing to Mr. I think Mr. Voss and anyway Mr. Sint-Veld, and I think some of you also mentioned it. As far as the new legal basis for the European Union as far as data protection is concerned is at stake, I think going on with the work you're doing it as fast as possible, anyway, would be very helpful also in the debate here, whether it's Article 42A restoring or having more exact grip on what we are saying and what we are doing. Giving powers to data protection authorities more than we have right now would be helpful in this debate as well. Leave it at that. Sorry to not giving answers to all your questions.
Thank you for your effort. Thank you for being here. Thank you for your effort to summarize. And let me tell you that we are counting more on you. We will be inviting the representative of the Working Party, Article 29, in a further occasion on data transfers. We're planning to hold a hearing, a special hearing on data transfers. Mrs. Romero, ¿es una cuestión de orden?
Sí. Sí, Presidente, es una cuestión de orden. Es que...
Just a point of order, Chairman. At the next meeting, we were told we would be reviewing the member states and their behaviour in the security area. We'd be looking at surveillance systems and then the secret services. But we need some information. Perhaps Parliament staff could work on this, because we've not been provided with information on this yet. Parliament staff need to press this point. This is something that we could perhaps debate on later on. As was said in relation to Echelon, there are more urgent issues. The governments are not keen to provide information. As our Echelon rapporteur said, we're keen to hear what members of the US Congress have to tell us, as well as American academics and firms. Those are the people who could provide us with some real useful information. Why not invite Frank Church, who carried out research on the NSA? So can we please invite the chair of the US Senate Committee? Well, it's planned that there would be a briefing paper on that very point, which will be circulated very shortly. The necessary plans will be made, but it's not at our next meeting that would be comparing national security in the various member states and the internal security strategy in the European Union. It will be in October.
Meeting of this inquiry is to be held September the 28th, but we having the 24th, I'm sorry, the 24th, but the next LIBE committee will be taking place in Brussels, say 16 to 18 September. But this LIBE inquiry, we will be developing it further on the next meeting, September the 24th. Please take note. Thank you. Thank you all. Thank you.